Hey fellow classmates, it's Lisa Glover here in North Carolina, and today I wanted to talk to you about something that's gained a lot of controversy, and that's the Second Amendment. According to the James Madison Research Library, during Virginia's convention to ratify the U.S. Constitution, Patrick Henry spoke up and said, "Guard with jealous attention the public liberty. Suspect everyone who approaches that jewel. Unfortunately, nothing will preserve it but downright force." Henry, of course, was an unabashed anti-federalist, and he was very concerned that the Constitution didn't contain a set of enumerated rights that would protect the people from the power of just a few. But what was this force that Henry spoke so eloquently of in those words? What was he actually talking about? I believe he was actually speaking of what later became the Second Amendment and the citizens' right to bear arms. The Second Amendment states, "A well-regulated militia, being necessary to the security of a free state, the right of a people to bear and keep arms shall not be infringed." This Second Amendment eventually passed quite easily through the states because they were under the understanding that the federal government should not have the power to infringe their right of bearing arms any more than it should interfere with their right to freedom of speech. Shallop actually expands on this idea in his article on the ideological origins of the Second Amendment. He argues here that an armed populace and their willingness to defend themselves is actually the bedrock, the palladium of Republican liberty. This statement of American freedom and rights has been in great controversy the past few years. However, the Supreme Court began addressing this in the 1800s. In 1875, in the court case of the United States versus Cruikshank, the Supreme Court ruled that the purpose of the amendment was to restrict the powers of the federal government. The Supreme Court ruled again in 1939 in the United States versus Miller. In this case, Miller was transporting a sawed-off shotgun across state lines and was arrested. The Supreme Court then ruled on this case in conjunction with Article 1, Section 8 of the Constitution, which is the Militia Clause. In essence, the court ruled against Miller's individual right with the understanding that the local states could limit accessibility but not prohibit it. That was the last time the court ruled on this amendment until the year 2008, where they got to rule on the District of Columbia versus Heller. This time the court looked at the Second Amendment in terms of personal liberty and protection and decided that the Constitution did allow individuals the right to possess a firearm for traditionally lawful purposes such as self-defense. According to the Law Library of Congress, this ruling also affected two other District of Columbia laws, which one banned all handguns, and the second one said that all lawful firearms, if they were in the home, had to be disabled or trigger locked. The court ruled both of these to be unconstitutional. Currently, this debate basically boils down to regulation. How much or how little regulation should be allowed by the government before it's considered infringing on the rights of its citizens? Nelson Lund's article, Not a Second-Class Citizen, he argues that this is not going to be a precise science and that it's one that will always have controversy surrounding it. People tend to have very strong feelings about guns. Some of that depends on whether or not they were raised around them, whether or not they were taught to fear them, or if they were shown how to properly use them and what is the purpose of using them. We understand that we are image bearers of God, but yet that we live in a fallen and sinful world. That means that when we are given liberty, when we are given choices, sometimes people choose wrongly. Sometimes they use that liberty to hurt others or bring harm to others rather than defending those who can't defend themselves.